This is video 1 of a 3-video series we're creating on the subject of what you should know after your divorce in Washington State. So this is Washington State law. If you got divorced in a different state, these rules may not apply to you. This first video is on the decree. The next 2 videos will be on parenting plan issues and child support issues. If you don't have kids, you can obviously skip videos 2 and 3. Now, you probably did not get this information from your attorney, so make sure that you stay tuned till the end. Okay, let's get into what you should know. You want to revisit your life insurance beneficiaries. Chances are you don't want your ex receiving your life insurance proceeds. The second thing you should know, you probably don't need to go back and revise your will, even if your spouse was listed as your primary beneficiary. Washington has a law called automatic spousal revocation, and just like it sounds, it automatically removes your spouse from your will when that spouse becomes your ex. You may, however, still want to go back and revisit your will if your will is now ambiguous, if it's unclear who your beneficiaries are, or if you want to add beneficiaries. The third thing you should know, if the opposing party violates one of the orders in your divorce, so let's say the person violates something that is required in your decree, don't call the police. That probably won't get you anywhere. Instead, you should file a motion for contempt. That's the proper remedy. Number 4, don't be offended if your attorney issues an official notice of withdrawal at the end of your divorce case. That's customary, and it doesn't mean that your attorney dislikes you. Similarly, it's not necessary that your attorney withdraw, so don't worry if your attorney didn't. Number 5, you can't modify the property and debt distribution in your decree. So even if your income goes way down and the opposing party's income goes way up, or let's say that the assets you were awarded in the decree aren't worth as much as the court really anticipated, you still can't go back and modify that property distribution. It's pretty much set in stone. Number 6, you can modify maintenance if the parties' financial positions change fairly substantially. So let's say your income goes way down or the opposing party's income goes way up, you might want to ask for a maintenance modification. But something to keep in mind, you can only modify maintenance so long as there's an existing maintenance obligation. So don't wait to tell your attorney that you want an increase in maintenance. If you wait too long, it may be that the maintenance obligation ends and you won't be able to get any more maintenance. Number 7, tell your attorney immediately if you discover that the opposing party had defrauded the court in some material respect. So let's say you come across some documents that show that the opposing party was lying to the court in some substantial way about assets and debts. In that situation, your attorney can actually go back and have the divorce decree set aside, and you can get divorced again on terms that might be more favorable to you. In that situation, as I mentioned, you should tell your attorney immediately. If you procrastinate after discovering this information, it's less likely that the court will grant your motion to vacate. Number 8, do tell your attorney if you notice that there's a typographical or clerical error in your decree that impacts you in a negative way. So for example, if you were awarded property and the legal description is incorrect, tell your attorney about that so that your attorney can go back and make a correction. We can use what's called a CR60 motion to fairly quickly and easily correct these kinds of typographical and clerical mistakes. Number 9, a properly drafted divorce decree can actually act as a deed for purposes of real estate conveyance. So even if you don't have a deed, maybe there never was a deed because the court didn't bother having one drafted through your divorce process, you can use your decree to prove that you received that maybe former family home or vacation property or what have you. You don't need a deed, you can use the decree instead. Number 10, if your name is on the opposing party's mortgage, it may prevent you from making large purchases on credit. So it may mean that you can't go and buy a home of your own until you're off the other side's mortgage. Now there is a way around this that applies in some situations. In some situations, if the decree specifically says that the other side is supposed to pay upon that mortgage, and the opposing party does pay on that mortgage for 2 to 3 years, some lenders will overlook the fact that your name is still on the mortgage. So if it's been a couple years and you want to buy a home of your own, shop around for a lender who will overlook the fact that your name is still on the mortgage. The 11th and last item for this video. You can get a certified copy of your decree at the courthouse. It's fairly inexpensive, and you don't need an attorney to help you do it. Chances are you don't need a certified copy of your decree, just a regular copy will suffice for most situations. But if you changed your name through the divorce process, then you probably do want a certified copy. You'll need a certified copy to prove to various government agencies that your name has changed. For example, you'll probably want to change your name on your driver's license, maybe your social security card, and probably your passport. And as I had mentioned previously, the next two videos will be on parenting plan issues and then child support issues. If you would like to watch those videos, I would encourage you to go to our website and click on the Resources tab. There you'll find a number of articles, guides, and videos on various legal topics. And here is the web address for that resources page.